This conference will now be recorded.
As well as special guests Dan Fabrizio and Diane Gerofsky, the Mercer County Surrogate, to talk about wills and probate today. Thanks a lot.
Hi, my name is Ken Vercammen. I'm an attorney primarily in Edison, New Jersey, but I also have an office in Cranberry. And we like to periodically talk to groups, and because it helps people be educated to be able to take care of their families in the time of need. Someone passes away, and doing planning. Oftentimes though, people ask me, Kenny, why do I need to have a will? I'm married. Doesn't everything automatically go to my spouse? He goes, well, yes and no. If someone's married, but it's a second marriage and there's children from a prior relationship, it does not automatically everything go to the spouse. But also by not doing any kind of planning, you're creating a problem for people in the future, because you have issues with who's going to, when the second person passes away, who's going to inherit. So number one, and the surrogate, can correct me if I'm wrong, but when someone doesn't have a will, or the will is declared invalid because it wasn't signed correctly, or someone used some cheap thing online and didn't do it right, the procedure to distribute assets becomes much more complicated. Even if all the children agree on who's going to be the administrator of the will, you still have to sign the other, children have to sign an renunciation in front of a notary, and has to be filed with the surrogate. But if the children don't sign, all agreeing a renunciation, agreeing upon who's going to be the administrator, then oftentimes you have to file a complaint order show cause in the Superior Court. And I'd say, listen, we love our Superior Court judges, they're good people, but in order to get there, you're usually looking at spending in legal fees and court costs at least $3,000. Number two, though, there's also, if there's no will, or the will is declared invalid, the administrator typically has to take a thing out called the Surety Bond, and you're paying money for the Surety Bond. So again, part of doing planning is, don't you want to have your kids have to spend less of your money after you pass? By doing planning, you're making things easier for people that have minor children. Well, if there's no will, usually say like a stranger determines who gets custody of children. That's a Superior Court judge. But the most important things, it often causes arguments, fights, sometimes lawsuits amongst families. So when the family's in mourning after someone passes away, there shouldn't be one more thing they have to deal with. So think about who do you want to get your assets, who you don't want to get your assets. If there's children, you certainly don't want an 18 or 19-year-old to inherit money, because they don't do things wisely. And beware of these online forms that say these are perfect for you, these are good everywhere, because oftentimes they are not. So now, believe it or not, the procedure to have documents prepared has gotten easier. The old method was someone would call up the attorney over the phone, and they would say, okay, I want to schedule an appointment for this day, this time. And you'd come in and you'd take out, they'd give you you'd start writing stuff down, and it became inefficient because a lot of times we couldn't understand people's handwriting. So even before COVID, we try to make it easier for people. The attorneys email someone a questionnaire, and either that person or one of their kids can help the parents. They're going to type up things: who's executor one, who's executor two, if they pass, who gets their things. And you always want to have a what if one of those people isn't around, who would get their share. Don't have anything dangling. I take advantage once I get the questionnaire, and I try to call everyone up. If someone wants to drive into my office and sit down with us after they've typed it up, then we're willing to do that. But a lot of times I'll say, aside from trying to see my smiling face, why do you think you need to come in? because I can talk to you like, use it when I'm driving with the hands free. I'm listening. I got all the time in the world when I'm driving. And, we find for the majority of people, that's easier. Some of our, like my seniors, they say, well, I really want to come in. I really want to come in. Okay, that's fine. So what are some of the things that you want to provide, type up or give to the attorney? Well, obviously, your correct address. And again, some people don't have email. That's okay. Their kids or a friend can help them. We just have to be careful though of the conflicts and competency, because when I see a form filled out where one kid is getting everything, that's all of a sudden you got to think, wait, what's really going on here? Let's see, even before COVID, some people couldn't get into our office, and I've been to, people's houses, care facilities, hospitals. But before I go, I want to talk to everyone over the phone first, because I have to make sure it's what that person wants, not what their caller wants. And just a quick story. Like Johnny calls me up. Oh, mom wants to do a new will and leave everything to me, and mom also wants to sign the house over to me. Okay, when can mom come in? Well, she can't. She's on an oxygen tank, but okay, we have a form that the doctor can sign saying the person's competent to do, like a will, power of attorney, living will, whatever the document. Plus also, but then I want to talk to him. And in one, this one instance, Johnny puts mom on the phone, and mom said, "Okay, Mrs. B, what do you want to do?" Oh, I want to turn over the house to Johnny. But for a lot of attorneys, that would be perfectly good. But I got to ask the next question because I know the answer. Mrs. B, how many kids you have? She goes, I got 3. I said, I know that. So you want those other kids not to get everything and Johnny to get really everything because all you have is a house. Oh no, I want all my children treated equally. That's what I thought. Put Johnny back on the phone. I go, Mrs. B, listen, let's see, just turning the house over to Johnny probably isn't the best thing for you because the other kids aren't going to get it. Don't rely upon Johnny saying, yes, I'm going to share with my brother and sister. But more importantly, one of the dangers of just signing over the house to the other kid for one of the kids is, can you guarantee that kid is not going to pass away or get divorced? And we had a matter in Monmouth County where sometimes putting the assets into an irrevocable trust to protect it from Medicaid is best for someone. But this one fellow in Monmouth, I didn't handle the underlying case, but he decided just to turn everything over to his 2 kids. And he goes, okay, if I live 5 years and, Medicaid can't touch my stuff. Well, unfortunately, his son passes away. So now who owns half of everything he owns? His daughter-in-law, who can do anything really what she wants. So think about that before just saying, I want to give everything away while I'm alive to my kids. Okay. What do you want to think about? Well, okay. Who's executor 1? Who's executor number 2? And we tell people never have joint executors. Let's say you could have 2 kids, you love them equally, they could be twins, but in a way you're kind of giving them twice as much work, because that means that 2 people got to fill out the paperwork with a surrogate. 2 people really got to sign every check. 2 people have to sign the listing for the house. 2 people have to go to a closing, and 2 people have to do everything. It's better to have one number 1 and a number 2. There should be one person as the captain of the ship and someone as the secondary person. That's why there's only one steering wheel. And that could be for matters where both kids get along. We've had probate cases where, the kids were just fighting. They couldn't agree upon what color the sky was. Kid number 1 says the sky's blue. The other one says, no, the sky's gray. You're stupid. You've always been stupid. So, it's better to have one and then the other. Listen, if someone insists upon it, I say, I'll do it, but that doesn't make sense. Then you got to think about, okay, who's going to get your assets? And if one of those people or kids isn't around, or it goes to a charity, that charity, who would get that person's share? But remember, there are certain assets that the will can't control where things go. They pass by by title, not under the will. So a common example is if a house is owned husband and wife, automatically goes to the survivor. A will can't change that. If there's bank accounts that are POD, payable upon death, joint tenancy, joint right of survivorship, automatically go to who's ever alive. The will can't change that. And I've even been recommending some people, I goes, listen, if you're not 100% sure, it's best that you get something from, wherever you have accounts, just confirming if you have beneficiaries or not, because the will cannot undo what you've already done. Certain assets pass by contract. Think of IRA, 401k, life insurance, annuities. We received, someone wanted to retain our office because, the lady says, my dad put me as the beneficiary on that annuity. I saw the paper and the estate won't give me the money. It goes, well, he may have shown you the paper, but it never got into the hands of the annuity company. And, it goes, don't waste your money. You're not going to win that. What your dad may have told you, is not going to be controlling upon a judge. And, I believe in being brutally honest with people all the time. Even if someone says, I want to retain you to, fight for that annuity, he goes, well, what grounds do you have other than dad may have said X numbers of years ago? All right. So, now, in addition to like, you having, who gets what we call a residuary, many people have what's called specific bequest. Now, what's a specific bequest? Someone is leaving specific amounts of either money or particular assets to, a person, charity, family member, whatever. So common example is someone says, I'm going to leave $10,000 each to my grandkids. Sometimes the ladies say, I want my jewelry to go to my granddaughter because I know my son, if he's the executor, he'll just bring it to cash for gold. He goes, hey, what do you give me for this junk? I just, give me the least amount of money. Some of the men were sportsmen, they have firearms, and they're saying, listen, it has to go to someone that has a bona fide firearms permit. Otherwise, like, the estate, to oftentimes just calls the police and say, take this stuff, and they melt it down. Now, also, you should be clear in your will. If you're making specific bequests, couple things. If that person passes away, the bequest lapses, or who would get that person's share. Other times, and you also say if this asset ceases to exist, then again it lapses, because sometimes someone might say, if the jewelry is already given away, then they don't get the value of that. If you're leaving money to a charity, be clear that if the charity ceases to exist, who gets it? And also be clear on what the charity is. It can't just be the American Cancer Society, because there's different sections of the American Cancer Society. There's the New Jersey chapter, local units, National American Cancer Society. You can't just simply say St. James Church, because there's more than a St. James Church. You don't want to just say wounded veterans, because like if you go on the internet, there's a whole bunch of entities that claim that they are the wounded veterans. So just a couple of things to think about. But again, it's your right to do with your assets what you want. More and more people are saying, listen, I'd rather leave it to my grandkids because they need it more. My kids are already well off. They have their own house. They don't need the money as much. Some people are saying, especially with second marriages, I recommend don't just leave everything automatically to your spouse, even if you love them. You can set up what's called a testimonial trust within the will. They're taken care of, but then the money goes to your own kids rather than conceivably your spouse's new spouse or their kids. So think about that. And one of the other reasons why I want people to type up or decide before speaking to us is, we had people coming in that, they'd had the interview form and nothing was listed, and because they hadn't decided. I goes, well, I can't be your mediator or your peacemaker. You kind of have to decide that ahead of time. So, those are specific bequests. Now, Your will can also have what we call the reverse specific bequest. I leave nothing to name of people. We don't leave them a dollar, nothing to that person. And again, that is your right. Uh, Last year, like a potential client said that, or a client said, "Do I have to leave everything to my kids equally?" He goes, "No. What do you have in mind?" And she goes, "Well, one of my kids um, lives on the West Coast, and we don't hear from him much." I go, "Well, did you get a card or a call from him on Mother's Day, or your birthday, or Christmas?" And she says, "No." He goes, "Why would you leave that person anything?" Let's see. I remember when I was in college and I said, "Oh, I got to call my mom. It's Mother's Day." And it's before everyone had a cell phone and I'm working at some place. So I used the phone there. "Hi, Mom. Happy Mother's Day." She goes, "Thank you, but Mother's Day is next week. You're a week early." He goes, "Oh, well, that's good." Rather than a week late, like my brother sometimes would be. Oh, sorry, I missed. But again, it is your right to do with your assets what you want. Now, some people don't have close family members. So again, it's your right to decide, hey, who do you want to get your right? And we did a will for a little old lady that she didn't have any children. Her spouse was predeceased. Her sisters, she had some third cousins on the West Coast. And she goes, "You know what? I'm leaving some, a portion to my neighbors that were always good to me. Not because they thought they were going to get money, but because they were nice people. I'm leaving some money to my hairdresser. Yeah, she got paid, but she needs it. She's not well off." And talking about well off again, most people say, "Listen, I love all my kids equally," but one of our clients said, my oldest daughter, she's married to Dr. Rosenberg, the plastic surgeon. Their house, their house in Princeton is worth $2 million. Their house on LBI is worth $2 million, and they're pretty well set. The number two kid's doing okay, but number three kid, her ex-husband's a bum, doesn't pay child support, doesn't pay support. She really needs it more than the millionaires. So that's someone's right. So, and we also usually put clauses in wills to not have young people get money outright. They, instead of like, might say they get their money when they're age 25. Or with minors, we usually say they get some when they're 22, some when they're 25, the balance when they're 30. But as much money as is needed can be, given for college education, maintenance, support, etc. Let's say we got some like for the Mercer County program, some 50 or so people that are listening tonight, and I see all the time. You got to decide, hey, would how much does college cost for your grandkids? A lot. A lot. And there's no way, maybe like, people 40 years ago, you can get a part-time job and pay for a chunk of college. You can't, a part-time job is barely going to pay for your books. Sometimes it's a good idea to do a testamentary trust where someone has like is a spendthrift. They just blow all their money. They could have alcohol problems, drug problems, substance abuse problems, mental problems. It doesn't make sense to give a chunk of money to someone that would not be able to use the money wisely and gets taken advantage of. And so that's why we set up these testamentary trusts within the will. Now, there's a difference between what's called a testamentary trust and a standalone revocable trust or like uh, irrevocable trust. So, um, my mother-in-law used to call me every other year and goes, "I want to come in and get a trust done, put my money into a trust." And I would say, "Were you watching Susie Orman?" And she would smile and goes, "Oh, yes." I go, "Susie Orman is so right. If you are in New York, Florida, California, where the probate process is so complicated." When my father-in-law passed away, like, you know, you know, only one condo with 200 and whatever $1,000, and I think the fees are and court costs, etc., are over 10 grand. So when someone wants to have a trust in New Jersey, it goes, why do you think that you need to spend 4 or 5 grand on setting up this complicated trust, changing the assets to be owned by the trust, when typically a $400 or $500 will do the same thing. And probate in New Jersey is not expensive. For most of the time, and the surrogate's going to correct me if I'm wrong, and the county surrogate we're proud to have on tonight, but most of the states, the probate fees are under $200, and you don't have to, it's not every step along the way like other states having to be approved and countings and things like that. So New Jersey's a probate easy state. So think about, who do you want to get your assets? Should someone get it outright? Someone not get it outright? And now a testamentary trust within the will is where you're picking a family member to be a trustee. It doesn't get funded, spring into existence really, until someone passes away, and then there's money to fund it, and it can be used to pay for, let's say, rent, etc., for the kid. Or that's the one that has difficulties. In the next town over in Somerset, someone had they didn't challenge the will, but what they did was the ex-wife was owed alimony and filed a motion in family court asking that the court compel the trustee to pay her money out of the trust. And the judge, we briefed it and went in for oral argument, and the judge agreed with me. The reason why you set up trust is to protect it from really everything. You're protecting from within a trust. Medicaid, you're protecting it from taxes, you're protecting it from alimony, you're protecting it from all of the creditors, and it's the trustee's discretion in which to do. Some people insist upon what's called a revocable trust, because that's what they heard about, and their friend sometimes it's their friend in California or whatever has one. I goes, okay, first of all, a revocable trust does not protect assets from anything, because it can be revoked. And the trust salesmen sometimes try to sell them, oh, a will is a public record, but a trust is private. Well, a public record, it doesn't have a list of your assets. It just says who gets your stuff, and most people are not looking to put crazy stuff in their wills anyway. However, some people would benefit by what's called an irrevocable trust if they're looking to protect assets from nursing home, Medicaid, etc. But that means that it has to be retitled and owned by the trust, not owned by you. Your trustee has to have control, and it's a 5-year look back period for the purposes Medicaid, etc. So, some people ask me, well, what's the pros and cons? Well, the pros is if you live 5 years and then have to go to the nursing home, it's protected. Obviously, the con is you're paying $5 or $6 grand to have the attorney set up the irrevocable trust, and then assist in transferring the assets into the revocable trust, doing new deeds, etc. Again, the positive there is that, well, if someone has to go in a nursing home costs substantially more than the $5,000 you might paying. Going into assisted living is more than 10 grand typically. So that's where you're spending your money. But so logistically, let's get back to the wills. The attorney prepares the documents. We're trying to be environmentally friendly, remote friendly. For most people have email, we will email them the proposed drafted documents, and we say, listen, and then we tell the people, okay, we suggest you print this at home and then read it, because you'll more carefully read something that you've printed. And then if everything is good, then people have the option of either signing in our office on Tuesdays when we have witnesses, or most of the people have decided, it was easier for me just to go to the UPS store or a notary on the weekend with, 2 of my friends as a witness. And that way we don't have to drive to your office and wait. Remember though, let's say, and if you're taking notes, write this down. only the original will can be admitted to probate by the county surrogate. Let's say, for the people, people would say, I don't understand. What is the surrogate? Well, it's a constitutional officer, et cetera, et cetera. Let me tell you what, it's really kind of the fancy name for the will clerk in Pennsylvania, whatever register will. So the surrogate's going to go over what the surrogate is, but remember, the will is a photocopy. The surrogate's going to say, I'm sorry, you have to go see, and it's not just see the judge. You got to file a complaint or to show cause. So if someone has a will and you can't find, and where you're alive, if you say you don't know where your original will is at, my rule of thumb is if you can't find it in a couple of days, have a new one done, because the whole thing is making it as easy as possible for your family, not to try to make it more difficult. Okay. The original will is kept by the client, not by the attorney, for two reasons. Number one, because the Supreme Court had a memo about over a decade ago that says, listen, it's the client's property, not your property. And plus attorneys retire, move on, and every other month we get a call from someone, do you have someone's will? I go, no, we have not had an original will in our office since maybe 2002 when this memo came out. So if you can't find the original will, it's a good idea to have a new one done. Oh, and by the way, for the people that are listening, typically we charge a consult fee. But if someone contacts us within 30 days of this seminar, then we don't charge the consult fee, and we email out the questionnaire and I talk to people. Okay, that's our little bit on wills. Let me move next into the power of attorney. Let's see, what a power of attorney really is it's like a will takes care of your assets if you pass away. What the power of attorney is you're giving the power to a family member or close friend the ability to act on your behalf legally. The power of attorney is effective typically either right away or only upon disability. If it's effective right away, typically there's language that says it's effective right away until someone becomes disabled. So that's a durable power of attorney. And I usually recommend that as opposed to effective only upon disability, the springing power of attorney, because the problem is you could have a perfectly good power of attorney prepared by, one of the best, lawyers around. But if they go into the bank and it's effective only upon disability, the bank might say, well, how do we know the person's still disabled? What proofs do you have that they're disabled? What proofs do you have that they're not around? So it's better if it's, in my opinion, if it's effective right away. Our last year, one of our clients says, Kenny, I don't understand this legal term, durable and springing. He goes, I'm a carpenter. Explain to me in union worker carpenter language. Okay, if it's effective right away, your son is the agent, and that gives him the power to do almost anything he wants. So he could steal your money. I mean, obviously it's not legal, but he has the power to go into the bank and take your money. If it's effective only upon disability, he needs a note from a doctor that you're disabled before he steals your money. Knowing that, Fred, you trust your son. He goes, oh, I trust my son with my life. Good. Make it effective right away. Now, similar to the what I mentioned on the will, be careful of these cheap or free things online because they tout stuff, but the trouble is, a bank may not honor it. And a lot of the banks, like the big out-of-state banks, were giving people a hard time. So the legislature some years ago, the power of attorney statute said, listen, if it makes reference to the New Jersey power of attorney statute, then the bank has to honor it. Otherwise, they're really in violation of state law and Department of Banking regs. But it does have to make reference to the in New Jersey, it's Section 2 of PL 1991. The statute's 46:2B-11, and a lot of free things oftentimes don't have that. We've also revised our power of attorney over time to include even medical language, like both designated caregiver language under post. Now, a will that's done in 2022 is valid 10 years from now. It's valid 20 years from now. It's valid 30 years from now. Let's see, but that doesn't mean you shouldn't have it updated if things change. But we do recommend people re-sign the power of attorney every 5 or so years so the banks don't give you a hard time. Oh, and by the way, talking about old documents, who should be the executor? Who should be your agent? Well, kind of our rule of thumb is, can they drive to a surrogate's office and park a car and walk to the surrogate's office and do the stuff? Can they drive to a bank and do what needs to be done? I'm not anti-senior citizen. I am practical because I was joking with our surrogate earlier. He goes, okay, I know in Middlesex County, there is no easy parking near the courthouse. There is no handicap parking outside the building like there is on TV. So now, a power of attorney, after it's signed, it is a good idea to scan it, email it to yourself, to your agent, and then email the power of attorney to your financial advisor, your life insurance person, your accountant, anyone who has information dealing with your assets, so that they already have it on record. Although I mentioned a scanned will or copy of the will can't be admitted to probate, it's still a good idea to sometimes scan it where you're sending it to Executor 1, Executor 2, with a note that says, my original is located at whatever place you're going to keep it at. You don't need to hide it in the freezer. Most people just go to Costco and get a fireproof box, and but it has to be in a place where someone can get to it. And we found the safe deposit box is one of the worst places because, well, what happened in March 2020? Well, the banks were closed to the public for a while. Good luck trying to get something out of a safe deposit box. Let's see, a lot of banks get taken over and their record keeping isn't that good. My dad put me on his safe deposit box. He gives me the key, and one day I goes, you know what? This is some years ago. I never been to a safe deposit box, and he said my kids' bonds are in there. I'm going to go check it out. And I go to the bank, and I have the key, and I have the my ID. And now the bank originally was like Metuchen Commonwealth, then becomes like First Union, then First Fidelity, and Countrywide, but then it becomes Wells Fargo. Ugh. Wells Fargo. Oh, you're not on the account. You're not on the safe deposit box. He goes, no, listen. If my father, the engineer, says he went to this bank and put me on, I know he did it. He's not like an old guy getting lost driving a ShopRite. He did it. Oh, Wells Fargo. Oh, we can't find the paperwork. So, sometimes, part of doing planning again is making it as easy as possible for the family. The last document, and by the way, I put in the chat, some people that work for some of the corporations, part of the coverage, similar to getting a free pair of eyeglasses, is getting a free will, a free power of attorney, a free living will. So, examples of those in New Jersey is MetLife covers some of the Princeton employees and J&J employees. Arig Legal Plan covers some other J&J employees, Merck employees. There's other company that does legal plans. It's called a Legal Access. So, again, we're here to help. And by the way, I'm going to finish up on living wills, but believe it or not, the surrogate's office is there to help also. The surrogate's office is not like trying to call motor vehicles and try to find someone to talk to and answer your questions. They're to help you and answer questions, because that's, they're nice people are hired to work in the surrogate's office. Okay, the last thing we're going to talk about is the living will advance directive. People in New Jersey have heard of the Karen Ann Quinlan case and the Terry Schiavo case, and the Terry Schiavo case was where, the person was declared brain dead by, a team of doctors. The husband, but she didn't have a living will, advance directive, and the husband has to petition into a court. But then the wife's family opposed it, saying, well, no, she's there's hope for her. We were talking to her, and like, you know, her eyes blinked, and she's listening to us sing on the hospital. Tried to say, no, 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 that's an involuntary thing. But you know, again, the whole idea of having the living will, advance directive, you know, health proxy it's really not for you because you're already gone. It's so your family does not have to go through the kind of trauma of having to make that decision if you have not done it ahead of time. So typically in the living will, you're saying, you know, fluids, nutrition, yes or no. And I remember one time a doctor asking me the ultimate question for someone that was, you know, in the hospital, and the doctor goes, "Okay, should today be the day?" And I said, "Geez, doctor, you know, I feel bad. I mean, I know the right decision was for someone who's 92 years old that's not going to open their eyes again, but you know, it's painful to have to be that decision maker. I couldn't even do it when my you know, my first dog was so sick that we had spent $16,000 on vet bills. Originally, it was going to be 8,000. It becomes 16,000, and you know, I still, you know, when the doctor said, you know, when the vet says, okay, you know, the dog's not going to get any better, I still couldn't go in and if it was my decision, I would have bought the dog home and spent more money because the dog was my dog. Okay, what are some of the, and I took language, some of the language from the medical society, because in a way, the living will document is a little less formal than the power of attorney or will. It doesn't have to be signed in front of an attorney. But again, fluids and nutrition, yes or no. Probably 85% of the people now say, listen, if there's no hope for me, you know, I don't want feeding tubes, etc. Now, don't be scared off from having a living will advance directive. It's not that they're not going to resuscitate you if you have a heart attack, if you're like, you know, going to like, you know, Walgreens to buy vitamins. No, the medical people are going to do immediately what they can. It's where there's no hope for someone and you can't talk for yourself. Remember, as long as you can talk, you're still the captain of the ship. And then we typically have like directives as to medical treatment, you know, and, you know, 99% of people usually say, listen, I don't want to be on respirators. If there's no hope of me regaining consciousness again, you know, don't be scared off. I mean, if someone like, you know, 2 years ago got COVID, yeah, they would have been put on the respirator because it was, you know, just to make them better. And you also, you want to have it in your living will advance directive, an agent 1 and an agent 2, similar to your will is executor 1, executor 2. And it's best not to have a joint person because then that means 2 people got to decide. And it doesn't, by the way, the person who's your agent in your living will does not have to be the same person who's your executor. So some people might say, listen, I'm going to have this child as the number 1 in the will and power of attorney because they're good with finances and money, but I'm going to have this other person in my living will because they're very good with, you know, they know medicine. You know, my daughter's you know, an RN and she does it. So, you know, and also, but I also like kind of joke, you know, you're the person you pick, you kind of want to, you know, the person that you want to carry out your wishes. I've been married 32 something years, and you know, I remember when you're first married, you're all lovey-dovey, and my wife, when we were doing the documents, says, "Oh, I could never let them pull the plug on you." I goes, "Okay, fine, I'll just leave my dad because he's logical like Mr. Spock." So then after I'm married 25 years, my wife goes, okay, so if you die, I get $850,000 in life insurance tax free, and I can quit my job and never work again, right? Well, can we pull the, basically, you know, we're joking, can she pull the plug now? You know, while I'm like in George Bailey, I'm worth more dead than alive. So with the living will, that document, we recommend after it's signed, you scan it, you email it to each other, you email it to your doctor. That way it's on record that you have it, and you know, let them know where the original is located. Oftentimes now, my next, I'd say so. You know, my name is Ken Vercammen, and I'm an attorney in. My main office is in Edison, New Jersey, but I spent enough time in Mercer, running in Mercer County Park and the surrounding areas. But I am so pleased that the Mercer Surrogate is joining us, and she can tell you like what I said that's wrong, etc. But more importantly, the for literally a year, the process was so complicated, but now that's opening, it's a surrogate. Please tell us how easy everything is in Mercer County, and also and pronounce your last name the appropriate way, not the way I pronounce it.
I'd like to say thank you, Ken, and good evening to everyone who's joined the seminar. My name is Diane Gerofsky, and I am the Mercer County Surrogate Judge, not clerk. We're statutory judges, and we're judges of the Surrogate Court, which is a limited court of doubt or no difficulty. But besides being that, we're also deputy clerk of court, Chancery Division Probate Part, contested probate, removal of executors, formal accountings. We're deputy clerk of court, Chancery Division Family Part. All adoptions are filed with our office, and I actually certify the adoptions. I'm custodian for what we call STEAMA, the Surrogate Intermingle Minor Accounts. When minors receive money, they're under 18 years of age, and there isn't any mechanism set up such as a trust through the will. The money must come to the surrogate's court, and I oversee it till they're 18 years of age. And finally, it's been on hold, but I do marriage ceremonies. They've been kind of off the wall for the past few years. It's been a very difficult 2 years for the surrogates across the state collectively. In Mercer County, we were literally locked out of the courthouse for 7 months. We didn't have any availability. Our files are not virtual, so that meant we actually had to have computer access and contact with people. I literally moved the whole office into my home, the den that you see behind me, and worked by myself. I had no staff from actually March through July. And actually the joke was that people would line up at the curb to drop off wills or pick up the prepared paperwork. And I actually had a neighbor come knock on my door and ask me if I was a bookie, because it was constant traffic, 7 days a week, all hours, night and day. I managed to get through it. I did approximately 800 or 900 probates in those few months just from my den upstairs. Then I was able to actually move back into the courthouse again with no staff until October 5th, when formally they opened the courthouse, not to the public, but to staff. We are, as of the past 3 weeks, now been open to the public. You can still send your request in by mail. We can still do it by mail as commissions. We've been extraordinarily busy with people coming in. I've added to the staff, so I actually have 4 probate clerks available the whole time that we're open for your services. But we're still getting a lot of mail-ins beside that. As far as parking, we have no parking. We are probably the worst located surrogate office in the state. We're in the what we call the middle courthouse on Broad Street. We're on the 4th floor at the end of the longest hallway you could possibly go. 3 courtrooms, 3 witness rooms. It's a treacherous walk for anyone who's on the elderly side or disabled. Parking, you're usually, you would have to go a block or 2 minimally to a parking garage. There's only 4 parking spaces outside of the courthouse for disabled. And we're talking a courthouse that serves the family part and the civil part. So it's very, very, very difficult to come to our office. Up until the pandemic, I actually had 8 satellites offices throughout Mercer County. We're located in municipal buildings and in senior centers, but they've been slow in reopening due to the fact that the senior citizens or the municipal buildings aren't open full time or don't have availability to cater to our needs. So we have not opened up the satellite offices again. I'm hoping by fall or maybe into January we'll have that service available. But we do also have had home services where I personally do the satellite offices and the home services, where we do go to your home if you're disabled or if you're homebound, and we do the procedures in your home. Probate in New Jersey is extremely simple, and as Ken had mentioned, we're probably one of the least expensive states in the country to do probate. It's based on the number of the wills of your pages, or pages of your will, and it's based on the short certificates, which I will explain what they are. I would say the average is probably between 125 and 150 as far as cost goes. If you come within the prescribed period of time, you can come in and walk out of our office in 20 minutes with everything that you need to continue on with the estate. It's not like, as you mentioned, Ken, California. We actually, a woman had come in, she had her brother-in-law stay to do in California, and it was a 19-page application with a hearing, and she lived in New Jersey. We were fortunate enough, we're able to do non-resident probates. If you have an asset in Mercer County and you've not done any procedure in another state of the country, in the United States, and we have certification from that county that you've done nothing, we're able to bring you in as a non-resident, which means you'll be able to do this in New Jersey rather than flying to California. But you do have to have an asset here, preferably real estate or financial that was opened here, not in another branch. We do have several people who come in now for those who use the financial plan, and otherwise there's a lot of tax reasons that people like to come back into New Jersey rather than probate in some of the other states. The probate proceeding, if you have a will, you cannot probate the will until the 11th day from the day of passing, but you can start the procedure. And the reason that you are probating a will is because there are assets in your name alone, meaning solely in your name. You have a bank account in your name alone, a car is registered in your name alone, you have property that's in your name alone. Until you actually come in and probate the will, you're not able to do anything with those assets. You're receiving from us what we call executor short certificates. And this is what enable you to go to wherever those assets are to bring the assets into the estate. I do agree with the limited number of executors. It's difficult when there's several executors named. We've had as many as 5 people qualify as co-executors because mom did not want to slight any of the children, and none of the children were willing to relinquish the executorship because they didn't trust the other 4. So it is difficult because you do need double signatures, triple signatures, whatever, to a number of executors there are. We do keep the original will. It's necessary because it's a court document that we keep the original will, but you do get in return for the probate proceeding what we call letters testamentary, and that is basically your certification that you qualify as the executor, and it will be attached to a true plain copy of the will, so you will be leaving with a copy of the will. Again, the mention of a testamentary trust. We also do the qualification of the trustees for testamentary trust. And again, they are created through the will. The testator names the trustee, the intended trustee, and we qualify the trustee for that position. When you do have a trust in the will, we usually ask that you have legal send us the information. We do not interpret the trust for you. So we ask that you kindly have an attorney or someone of legal advice to send us the information. We don't require an information sheet before you come in. And when you come in, we'll ask you what we need to know before you do come in. Do keep in mind when you do come in to probate the will, we have to build an intestate family tree on the application, regardless of who is inheriting through the will. And this reason being is, had there been no will, there was a chance that these intestate heirs, meaning direct blood, would have the opportunity to inherit. Many times, and I cannot count the number of times it's happened, we get arguments over the counter because he's not in the will, he lives out of state, I don't like him, I don't want him to know. And unfortunately, we have to have that information. So if there's a spouse, we need the spouse and children. If they're just children and any of the deceased children, we need the next generation. So we have to build a family tree till you go to the very end. I've been the surrogate judge for 26 years. And I've clipped obituaries for 26 years, and everybody across the state laughs at me. But I found that it saves a lot of time when you go up to the counter and you have the obituary and it names 7 children, and you've only given me 3. it makes my life easier and your life easier ultimately. But probate is a simple proceeding. I find that we have very well. You were talking about doubt or difficulty. Let me backtrack to that for a moment. I have the right as judge of the surrogate's office to put an order of doubt or difficulty on a will that passes over the counter that does not meet New Jersey statute. And people say, well, what does that mean? One, I cannot accept a copy. Two, I cannot accept a copy where there's change of intent by pencil, pen, crayon, or whatever the matter may be. Also, there's a thing called self-proving will. That won't throw it into order of doubt or difficulty, but it'll hold up the probate process. If you don't have specific language at the end of your will, an attestation clause, two witnesses, notary, and specific language, we have to have a witness come forward to attest to the fact that you're 18 years of age, sound mind, and under no undue constraint. That will also hold up the probate process. That's one reason, particularly with the older wills. Your wills don't go stale, but I do agree with Ken. Actually, you should look at your will every 5 years and see whether there's changes that you want to make or if they do conform to self-proving. Self-proving came about in 1978. But for many, 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 many years, wills were not made self-proving at the time of execution, which means that we've had to find your witnesses. Some of them may be 34 years or later, and if they're not living, we have to find proof of subscribing witness. So do review your wills, and also for intent. Things do change, as Ken explained. You know, your children may have varying financial changes, so you may want to switch around who you're leaving, whatever, too. And for all those pet lovers out there, of which I have 2 ragdoll cats, I have a trust in my will for my cats, mainly because I find that nobody wants them unless they have money. So I've named a trustee, and I actually leave money in my will for my 2 cats so that I know they'll be cared for after I've left. Years ago, you could not do that, and people had people in the will named Susie. Susie was, because I worked for a law firm in the 80s, and Susie actually was a horse, but they couldn't say that they were leaving money to a horse, so they were just leaving money to Susie. So be mindful also not only of your children or your relatives, but also your pets. Also, we was talking about testamentary guardianship, not only for incapacitated people that you may be caring for now, but also for minor children. You know, something were to happen to both parents of a child, you can put in your will a testamentary guardianship that names who you would like to have the children if you're no longer here. Just as like when you're tending to somebody over the years who's developmentally disabled in some way or incapacitated, you're able to name a guardian to take over your role when you're no longer here. I do have a brochure file. I'll just hold it up here so you can basically see what it is. I've written, I like to write, so I've written many, many, many newsletters dealing with the trust situations, not having a will, having a will. But basically, I provided a 24-step checklist of what's involved in being an executor. But for those out there, don't panic. You're not going to have 24 steps. A lot of it's tax related, and a lot of you will not have tax issues, particularly if you're a Class A beneficiary. You don't have inheritance tax. And right now, New Jersey does not have a state tax. So it's nice to see what you may be up against when you ask someone to be your executor. They can see what they're in for. And I've also prepared a survivor checklist. Once you are the executor, it takes you through the steps from the point that someone passes all the way through, so you know where to look for assets that have not been shared with you. And then I do have one more, a booklet. This is where you can't really see it well, but it's a personal record book, and of you and your digital assets, so that you can mark down everything where you keep military records, your safety deposit box, passwords to your different computer programs and whatever, so that if you were to pass away, people could get into your e-banking, your e-trading, or whatever you need to get into. I see someone asking about checklists. If you just go to Mercer County, just go into D. Gerofsky, D as in Diane, Gerofsky at mercercounty.org. I can send you the whole brochure file. I just had a financial planner actually put an article in the Trenton paper, and I got 250 requests for the folder. I was like taken back by it. Now let us look at the second scenario. You don't have a will. You didn't take the time to prepare a will. So now you're looking at what we call the intestacy. And again, that's referring to the fact that you have to go by degree of kinship. In a will, you can name whomever you wish to be executor. You can leave your assets to whomever you wish to leave them to. They can be a friend, they can be an enemy, whatever. They don't have to be blood. But when you go into an administration, it's by blood. So it means right away your wife would have first right. If your wife is no longer with us, then your children. If you have no children, then we're bumping to your parents. No parents, we're bumping to your brothers and sisters. None of them, nieces and nephews. Then we're going up to uncles and aunts and cousins. I just did an estate that had 50 plus intestate heirs. I was down to cousins 3 times removed. That's how far down we had to go. And people say, why? Well, these people have a right to know that that there's an estate, that you're the administrator, and they have an interest in the estate if the assets tend to go that far down. You have enough assets. Again, in this case, we're requiring a certified copy of the death certificate, and very specific information as far as the amount. When you have an estate with a probate, we do not ask the value of the estate. That does not enter into the probate process. But when you don't have a will, we have to know the value of the estate, because if you're beyond the spouse and there are children of both blood, there's no bond. But if the children are of no bond or there's no spouse involved in it, that means, or no blood of the decedent, I'm sorry. That means you have to serve under a surety bond, which means that you have to be bonded for the value of the assets in the decedent's name alone. And that's another reason to make a will, because a bond is expensive. It can run thousands of dollars. I'm being dramatic, but based on the amount of the estate, and you have to go to a surety company, an insurance company, to purchase the surety bond. So not only do you have to have good credit and employment, you have to be able to be bonded before you can serve as the administrator. Once you've completed all the duties of the administrator, you're going to have to procure what we call refunding bond and releases from each beneficiary in order to get out of the surety bond. And they get filed with our court, and they have to basically conform to the amount of money that you were bonded for. And should it be much more than your bond, you're going to have to get a rider. But we would then issue you a certificate of release. I mean, by and large, as was said earlier, it's so much less expensive to just do an estate with a will. Have a will done, come in, probated. It's not expensive. You don't have a will, you're looking at bonding, you're looking also at renunciations, meaning all those people who are your intestate heirs on the application have to sign renunciations allowing you to serve in that position. And that becomes a problem, because locating people I'm almost like a genealogist in a sense. I spend half my time locating people for the people who do come in, because they have to be informed. If it's a small estate, which I'm going to touch on very lightly, again, no will, absolutely no will, because you're going to perjure yourself in an administration or an affidavit trying to bypass probate by saying there's no will, because the forms actually state there's no will. A small estate for a surviving spouse caps out at $50,000. And I need very specific information when the spouse comes in: make, model, year, serial number, value of the car, bank name, bank account number, and how much is in the bank account, because the affidavits can only be used for the specifics. If it's next of kin, meaning children or any other related, then it's $20,000. And that has to, again, very specific information on that. They're not expensive. They're less expensive than doing an administration. but they can only be used with specific, whereby in an administration or in an estate, or when there's a probate, the short certificates are not earmarked for specifics. They can be used for wherever you need to have them used for. This is pretty much, I'm just giving it to you in a small shell what we do, but if you do have questions, I am available. I'm full-time. I'm there every day, probably 8 to 10 hours a day. I'm more than willing to share information. I do have to put the caveat on it that we do not give legal advice. We refer you to an attorney. We can only speak to you within the realm of our position. So if you have a general question, I'll be more than happy to answer it. Otherwise, you will have to see an attorney. But Ken, I thank you for the invitation to join you. If anybody has questions, I see the chat's up to 11. I don't know how many are, and I haven't been watching it. Please feel free to ask me. And also, I'll also give you my phone number. For those of you who don't want to email or work, our phone number is 609-989-6331, and that's actually my number. We do not have voicemail. We do not have extensions. Thank you for putting 609-989-6331. Again, thank you very much for the opportunity.
Okay. Thank you, Surrogate. Our last speaker tonight is one of my colleagues, Dan Fabrizio, who's a financial advisor. He lives up the street in what you call it Princeton Junction, next to South Brunswick. But Dan, what suggestions do you have for our viewers tonight?
Well, I just thank you very much for allowing me to speak. My name is Dan Fabrizio. As Ken mentioned, I'm a financial advisor with New York Life. My main home office with New York Life is in Edison, but I work out of Mercer County and cover the entire state. And I live in Princeton, New Jersey. I worked on Wall Street for 22 years. Now I'm working with individuals instead of investment institutional investors. I'd just like to give a little advice on some of the areas to avoid mistakes as you enter or you get near retirement. And there's just seven areas I just wanted to touch base on. I'm not going to be as long as speaking as long as Ken or Diane. But item number one is not planning your retirement with your life expectancy in mind. You got to stop using your parents and your grandparents as estimates for your life expectancy. The reality is life expectancies are increasing more than they were 30 years ago, obviously because of medical advancements. The important part, I feel, is to rely on data and not a hunch. But be careful to not be fooled by actuary estimates. There's nothing deterministic about life expectancy estimates. Point number two, not being smart about claiming Social Security. Some people are still taking Social Security before the full retirement age. This means that if you apply for Social Security before the full retirement age, you're going to receive a smaller monthly check for the rest of your life. But if you have the financial resources and believe that you'll live longer than average, generally speaking, waiting to take Social Security at a later age means you're going to get a larger check for the rest of your life. So depending on your personal situation, and to learn more, go to the Social Security website and it'll explain in a little bit more detail. Item number three is taking a lump sum pension could lead to expensive mistakes. But thanks to annuities, it can help retirees meet their financial goals with a lifetime income stream when a lump sum payment is your only option. If you're able to receive a lifetime income stream through a company's pension, it may be a preferable option depending on one's particular circumstances. Item number four, too much risk in your investments as 1 year's retirement. And this is actually pretty good considering the financial markets over the last few weeks, particularly the last couple of weeks. Taking more risk with your portfolio when you may not need to dampen or reduce your retirement income, particularly if you only have a 401k and mutual funds. You're going to retire in another year, and the last three weeks, all of a sudden, you lost 30% of your retirement income. You want to be very conservative as you approach your retirement age, particularly if that's your only pot of retirement funds. So just be very conservative and don't take risks regardless how good the market is doing. Item number 5, buying life insurance as an employee benefit. While it's generally less expensive or free to take group life insurance with your company while you're still working, this coverage typically goes away once you leave your company or you retire. And if you're 50 and older when you retire, it can get expensive to begin buying life insurance at that age. One option is to buy permanent life insurance when you're younger and it's cheaper, in addition to the insurance that your company would give you. But if you're 50 and older, there are still some whole life insurance products, depending on your coverage goals, that can help you with your retirement plans. Item number 6 is focusing on assets over income. One mistake I've seen is failing to switch the mindset from retirement savings to retirement spending when you're in retirement. A main purpose of saving for retirement is so that you have enough money to spend in retirement. Say that you have $500,000 in your IRA, but in terms of living standards, what exactly does that mean? And based on your spending needs and other income sources, how will your assets be allocated once you retire? And can you safely withdraw 4 or 5% a year and let it last until you die? It's hard to know exactly what kind of standard one's living can have with all your assets in one type of account and product. Continue reviewing your financial situation with a financial professional throughout your retirement, and he can help you with your retirement plans and goals. And the final item, I want to touch bases on bank CDs. Older adults, when they retire, tend to store large sums of money into bank CDs because the bank recommends it. But the downside of bank CDs is that you lock up your money into a multi-year CD, and at the end of each year, the bank's going to send you a 1099 form with the interest you earned, and you got to pay taxes on that interest, but yet you can't spend that interest. The better options that's available, and that's if you're going to lock your money up for a few years, is think about a multi-year annuity instead. And here's why. You'll probably get a higher interest rate. 2, and the most important feature is the interest you earn is going to be tax deferred. This means you're not going to get a 1099 on the end of the year and pay taxes on that interest. And you'll only pay taxes on that money is when the annuity expires, or if you want to defer it further, you could just roll it over into another annuity and it remains tax deferred. Anyhow, those are the 7 things I just like to touch base on. If anyone has any questions or would like to touch base on anything further than that, I put my contact information into the chat, and feel free to reach out to me. I have my number and where I can be reached at. But that's all I have this evening. And hope, thank you very much for having me.
Let's see. Thank you, Mercer County Library. Dennis, any last things that we need to go upon?
No, I think you guys have covered pretty much everything, giving us all a lot to think about.
Outstanding.
Ken, thank you very much. Diane, Dan, good to have you on. And thank you everyone for coming and taking part in listening to our program.
Perfect. Be well. Thank you. Take care.
Be well. Thank you.
Thank you and good night.